Thank you very much, Program Director, Judge Mosi. The first question that was asked by the Honorable Member of Parliament, who was the first to ask questions, as I understood it, was whether the fact that the Constitution gives the power to appoint judges to the President doesn't erode the independence of the judiciary. I'm not sure to what extent the question is relevant for today, the performance of the courts. But it may well be that the Member of Parliament thinks that it may affect the performance of the courts. But the short answer is simply that the fact that the appointment of judges is made by the President does not and cannot erode the independence of the judiciary, because the independence of the judiciary that we talk about is the independence of the judiciary that is contemplated by the Constitution. And part of it is that, part of the Constitution is that it is the President who appoints judges. The second question was based on saying I'm a captured judge. Again, I think the question has no relevance to the report we are about today. I accept that, particularly for the work that I did as chairperson of the State Capture Commission, I made many enemies, and that some of them from time to time hurl insults at me, and some of them want to discredit me. But I believe that the majority of South Africans, as Mr. Dagmore indicated, know the truth and appreciate the work that I, together with all those who were involved in the commission, did. So I will not engage in a discussion whether I'm captured or not. The third question from the same Member of Parliament was whether I didn't think that what he called the decentralization of local divisions of the High Court would improve, as I understood his question, access to justice. I don't know what the decentralization of local divisions of the High Court means. I have no idea what the Member of Parliament has in mind. I've never heard that term. It may be that what he has in mind is a situation where there are circuit courts. So you have a division of the High Court, and then judges from time to time from that High Court go to outlying areas to do trials there. If that is what he was talking about, then I understand. And I can say that that is done all the time by the various divisions of the High Court, and the JPs see to it, and certainly it helps in access to justice. But I must also say, Honorable Member of Parliament, that when it comes to access to justice, to a very large extent, some of the things that need to be done in order to enhance access to justice depend on decisions that must be made by Parliament and the executive, and not by the judiciary. And monies that must be spent in order to build courts closer to the people. Money that must be spent in order to build more courtrooms. Money that must be found in order to create more posts for judges so that more judges would be available to do cases. To a very large extent, those decisions lie outside of the judiciary, which I maintain is wrong. But that is part of what we have been fighting for as the judiciary for many years, namely the institutional independence of the judiciary. We have been saying we want a judiciary-led court administration model for South Africa's judiciary. In 2013, I've said this in public, in 2013, the judiciary made available to the executive a report in which the judiciary set out what it envisaged as the model for the institutional independence of the judiciary and the judiciary-led court administration model. The purpose of giving that to the executive was so that the executive could see what the proposals were and respond and engage with the judiciary. They stayed for 10 years without responding to the judiciary. They responded only about a year or a year and a half ago. It's a delay. We had a meeting with the president on the 13th of December, myself and the president, to discuss this issue. And that meeting went quite well. But we had agreed that there should be another meeting within a few months to take that further. And that meeting hasn't happened despite my reminding the president that we need to meet. Recently, I've written to the president and said, President, please, we need to finalize the issue of the institutional independence of the judiciary. At least we need to get to a point where there is a memorandum of understanding between the judiciary and the executive as to what needs to be done in order to reach that level of institutional independence that is acceptable. And I've said to the president, before I leave, please choose any 3 days that suit you, and I will make myself available, because I would like to make sure that before I leave, we've made progress. But also I said so because at the judges' conference in December, it became very clear when this issue was discussed that the judiciary's patience is running out, and that the judiciary is beginning to say the executive is not serious about this issue, and negotiations between the judiciary and the executive don't seem to be going anywhere. And the judiciary is aware that in other countries on the continent, other judiciaries have gone to court in order to force the executive to grant the judiciary institutional independence, and they've been successful. Uganda is one of them. Zambia is another one. We would like this matter to be resolved through discussion. And we would like the executive to make it a priority. And one of the things that I hope we will not be arguing about with the executive, and I say it because in the response that came from the executive last year, the executive opposed our idea that the court administration model must be a judiciary-led model. But that is what the executive approved in the National Development Plan. It's already there, it's been approved. So I'm hoping that when we get to discuss this, the executive will not take us back 10 years back and say, let's talk about whether the model should be a judiciary-led one or not, because they have approved that it should be a judiciary-led. I'm just mentioning this because the honorable member touched on the issue of access to justice, and to say, to a very large extent, as the judiciary, we depend on the executive in order to enhance access to justice. Mr. Dagmore, thank you very much for your remarks. They are much appreciated. As far as the information about the lower court is concerned, we are hoping that next year we will have full information that the Department of Justice will be able to play its role. As far as translation is concerned, I think there are challenges with regard to translation services in the courts, but on the whole, the courts are able to proceed. But there is a need to professionalize those services. So that's what I can say, but any one of the colleagues must feel free if they want to add to those. Maybe before I stop, let me mention something that I had planned to mention earlier on, that we have a very interesting feature with the recent appointments and announcements, because I see that from 1 September, the Chief Justice will be female, the Minister of Justice will be female. Of course, the head of the NPA is female. And the president of the SCA is also female. Thank you very much.
Thank you, Chief Justice.